Okay, great. Good morning and welcome to an oral argument session for the 5th District Court of Appeal. My name is Rand Wallace and I'm presiding today. I have also joining me on the panel, we have Judge Edwards from Seminole County and Judge John Harris from Brevard County. Today at 9 o'clock, we have the case of Orange County, Florida versus Esther Whitehead. And I will assume, Mr. O'Connor, that you want 5 minutes of rebuttal unless you tell me differently.
Yes, please.
And so with that, we will turn it over to you all. And Mr. O'Connor, you may begin.
Yes, good morning, and may it please the court, Dennis O'Connor for Orange County. This is a single narrow issue that's before the court, and it's an issue where we believe Judge Helms incorrectly and improperly instructed the jury in this case on the issue of res ipsa loquitur. So we start, I think we first have to, if need be, have a discussion about the standard of review. We believe it's a de novo standard. This is an issue that really fundamentally altered this trial. It's an issue of, it's a question of law, and it changed and revamped the burden of proof that plaintiff had versus what the defendant had. Changed everything. And so it's a question of, it's a de novo question for the court, and we think the weight of authority supports that. Certainly in our Dufu decision, alludes to this being a matter of law. Cases from other jurisdictions seem to be in unison that it's a de novo question for the court. And so, gentlemen, this would be your charge conference. For all intents and purposes, you're deciding what jury instructions should have been read to this jury under the circumstances and facts of this case. And the authority, we've got the leading case is the Goodyear tire case. We also have the McWhorter case. We have the McDougal case. It's interesting that most of these leading cases all come from Central Florida. Indeed, 2 of the 3 come from right here in our backyard. And so we learned from the Goodyear case and the other cases that there are 3 elements that have to be established by a plaintiff to warrant the reading of the res ipsa loquitur instruction. And the first is that that direct evidence of negligence was unavailable to Mrs. Whitehead. And so we have Mr. Paul with us. He tried the case. We tried the case together. He's truly one of the best. And I think candidly he did too well as it relates to this argument. So what evidence did he adduce in the trial that speaks to direct evidence? He established an admission attributed to Officer Shaffer, the gentleman in the control room, that he closed the gate on Mrs. Whitehead. He established an apology from Officer Schaefer's supervisor, Sergeant D. Giovanni. He aggressively and effectively confronted and impeached Officer Shafer when he established through use of his deposition that he thought initially, based upon his review of the video, that it was possible he closed the gate on Miss Whitehead. And parenthetically, this case was really always about operator error on the part of Officer Shafer, and then secondarily, perhaps a maintenance piece.
Mr. O'Connor, I have a question for you.
Sure, Judge Edwards.
How is everything you're talking about not circumstantial evidence? There's no video evidence of Deputy Shafer pushing the buttons. There's no electronic audit trail. There's nothing else. So aren't we really talking there about circumstantial rather than direct evidence?
I don't think so. We have testimony of the gentleman in the control room. We have the actual video footage. What we don't have, and what could have been produced and could have been developed, is expert forensic technical evidence, whether it would be from an electrical engineer, mechanical engineer. This is pretty sophisticated equipment, as the record establishes, with buttons and circuits and gates, heavy gates,
But do you agree, though, that the gate should not have closed on Ms. Whitehead, correct?
I agree.
And the gate either closed because Deputy Shafer pushed the button to close it when he shouldn't have, or there was some kind of a mechanical failure. Is that correct?
Yes.
Okay. So if the jury believed he pushed the button when he shouldn't have, they could have reached a verdict in favor of plaintiff.
Yes.
And on the issue of mechanical failure, and you may want to make a note and get back to it and rebuttal, and that's fine. But when the jury asked the question whether mechanical failure or lack of proper maintenance could be considered negligence, and that's at record page 1576, 1577, and so forth, both sides agreed that the judge could say yes if you think the evidence proved that. So either way, the jury could have found it closed for either one of those reasons and still reach the same result with or without the res ipsa instruction. Don't you agree?
Yes, sir. Number one, I don't necessarily agree that testimony of Officer Shaffer is circumstantial. I mean, I think that's direct evidence of what he saw, what he did, what happened. Secondly, as to this jury question, I can't take credit for the response, but I would say, number one, it's not raised in the briefs. Number one. Number two, what happened was it was addressed shortly thereafter. It was brought back to the attention of the court, and the judge said what he said, that is, he would have, even had you objected, I would have made the same ruling. So,
Mr. O'Connor, you say that there was direct testimony from Officer Shaffer. However, in reviewing the record, to me, it was at best a little ambiguous as far as Officer Schaffer's recollection of the event. I think first, Officer Shaffer indicated that he doesn't really remember having what kind of there was a tone or something that would have been signaled when Mrs. Whitehead came in front of the video camera. Officer Schaffer's recollection of that was, I guess, initially he didn't remember, but then I guess based upon questioning, maybe cross-examination, eventually admitted to seeing Mrs. Whitehead in the video. Is that correct?
yes, the tone had to do with an intercom that apparently wasn't working, but the interplay of the intercom had nothing to do with the operation of the gate. It had to be manually triggered.
But the tone, I think there was even the use of the word malfunction with regard to the tone. Is that correct?
I know the intercom system for that gate 4, was not working at the time. I think the malfunction reference had to do with the gate opening and then suddenly, sort of in an anomalous way, closing back on Miss Whitehead.
Okay, and then at any rate, I think after some questioning back and forth, at first Schaefer did not admit to remembering pushing the button to open the gate, but then eventually admitted to at least pushing that button to begin the opening process. Is that correct?
To reclose it. He pushed the button to open it initially. It opens and stops, and this is in real time as he's watching it play out, as it sort of shudders and collapses back like an accordion on Miss Whitehead. At that moment in time, he concludes that he must have pressed the close button. And then when it backs out again, he then rethinks that in real time and concludes it's a mechanical anomaly. And perhaps due to the presence of the sensor, reason, but it was at that point he concluded it was a mechanical anomaly. So get back to Judge Edwards' question. I don't think we're talking about circumstantial evidence as it relates to the testimony of Officer Shaffer. I think it's direct testimony, direct evidence. The jury doesn't have to draw any inferences. The jury can draw inferences, but it's not circumstantial. And he was very effectively and aggressively impeached by Mr. Paul. He testified what he testified to, and the jury had that to consider. But in addition, to the extent the court is even thinking about this being only circumstantial evidence, what was available to Ms. Whitehead? If this was a maintenance issue, and it was in part a maintenance issue, why not have why not have a forensic evaluation? Why not have this very technical, mechanical, electrical equipment evaluate? That could have been done. But strategically it wasn't, and understandably so. The approach was simply to attack the operator and establish that he basically hit the switch and hit the button and caused the gates to close.
But Mr. O'Connor, was there any documented evidence that was admitted at the trial that would have documented any prior mechanical failures or malfunctions with regard to that gate?
No, sir. But there was evidence from Officer Cousins, the grounds, the maintenance person for the jail, that they had a dedicated crew of staff who handled these doors and these gates. In fact, they were called door guys, and they handled the electrical, the mechanical repairs, maintenance. There was a schedule. And no, the evidence at trial was not that this was always documented, but that's not fatal to the fact that there was evidence that it was done with some regularity. In fact, it was done on a schedule.
Mr. O'Connor, do you agree that there was no evidence of poor maintenance, or that this was due to a lack of maintenance?
There was no evidence of poor maintenance.
Okay, and in fact, in the appellee's brief, I think they even concede that point. So it really comes down to whether there was a button pushed by Schaefer when he shouldn't have pushed the button, or there was some kind of unexplained malfunction. Is that really what the case came down to?
An anomaly like we have in these in plenty of cases out of this district, dealing with escalators and elevators, and Judge Coward's sort of discussion about how we treat lawyers and doctors differently than we treat elevator mechanics. Nothing's perfect. The escalator case, there was a breaker that tripped. That's the Rothman case. And so we're not talking about a piece of equipment like the Rogue or Wayward tire that Senior Judge Harris talked about in the Chung case. This is not in the common fund of knowledge. This is technical equipment. And it requires for there to be a discussion about a maintenance issue. Would have required and could have evidence that could have been available to the plaintiff, technical evidence. What happened? How did it happen? Did water short the circuit? Was there a problem with the component that broke? What we do know is that this had never happened before at the jail, at least according to Officers Shafer and Cousins. And why it happened from a mechanical and forensic standpoint, we'll never know, because that was never pursued. Could have been, just as the deposition of the door guys, and that testimony could have been established. Their names were known. They were not pursued. I think the plaintiffs felt as though, with the testimony of Officer Schaefer, they had what they needed. And you review the closing argument of very eloquent closing argument of Mr. Paul. He recites and goes through 6 or 7, if not 8, separate reasons why the county was negligent because of the actions or inactions of Officer Schaefer. And he referred to the evidence that supported that. And then right at the conclusion of his liability closing argument, before he transitioned to comparative negligence and damages, he said these words, and it undercuts the first feature of res ipsa. That is, the evidence of negligence is overwhelming. Those are his words, and he felt that, and because he had so much, not just circumstantial evidence, Judge Edwards, direct evidence, and his primary target was Officer Schaefer. But right after he said, though, uttered that very powerful conclusory or penultimate expression, he said this: but I want you to do one other thing. There's a jury instruction. It's called res ipsa loquitur. And I'll quote now. Just read it. Close quote. So we have an instruction that shifts the burden of proof from the plaintiff to the defendant. And that question about mechanical failure, the only reasonable interpretation of that is that the jury had rejected the active negligence argument on the part of Officer Schaefer and was defaulting, was giving the plaintiff a fail-safe, no pun intended, to establish liability. So number one, there was the availability of direct evidence of negligence, and it was established by Mr. Paul on 6 or 7 or 8 different points. Now, the second feature of res ipsa is there has to be a showing that it has to be established that this sort of thing would not have happened in the absence of negligence. And so that gets back to the elevator and the escalator cases that we talked about earlier. This is not.
You're saying, Mr. O'Connor, you're saying that's the plaintiff's burden to prove those 2 elements, correct?
Yes, and there's a third, which is exclusive control of the instrumentality, and we acknowledge that, and I acknowledged that earlier to you, Judge Edwards. But so the question is, did the plaintiff establish that the injuring event would have occurred in the absence of negligence? The answer is no. There is no way. This isn't that road tire. This isn't the tire that falls as it was in McDougal, the tire that comes out from under the trailer carriage, with some of the equipment lost, the chains lost. And with a rogue or wayward tire, the assumption is that thing's gone, and it would be difficult to sort of reconstruct what happened. This is not that. Everybody knows that tires shouldn't come off of an axle as you're driving down 95. And that's a fear we all have. And it's within the common fund of knowledge. But an elevator or a gate that was described in some detail as a very large structure, very complex, mechanical, multiple hinges. They had a specialized crew of people to maintain the doors and gates. They're called door guys. I mean, they did preventative maintenance. They did corrective maintenance. So the county has an obligation to exercise reasonable care. We say they did. There's no evidence to the contrary. There could have been evidence adduced from technical witnesses as to what happened. Was it a sensor? Was it a short? Was it a piece of the original equipment? It just wasn't, for whatever strategic, it's certainly not a criticism of Mr. Paul. It was a decision. Lawyers make decisions on how to put on their cases, and I think the plaintiff felt like they had plenty of evidence of direct negligence to not have to get into the weeds on physics and science and electrical.
Well into your rebuttal time if you want to save any.
May I save a few minutes, Judge?
You may.
Thank you.
All right, Mr. Paul.
Good morning. If it may please the court and counsel, what we're here about today is an issue that Judge Helms looked at after hearing every single witness, watching the video, evaluating witnesses who were testifying during the video. And he really does put the issue clear if you go to the moment of the charge conference on page 1449 of the record, where he says, the question is whether or not this is one of these cases. And then what he does is he uses a foundation of the Florida Supreme Court standard in Goodyear versus Tire. And then at the end of analyzing everything, he actually articulates his holding and says, in this particular case, I believe the plaintiff has met their burden. We disagree initially on whether or not Judge Helms is entitled to discretion, having sat in the trial court and listened to the witnesses and evaluated the witnesses, when the issue is not that he said a misstatement of the law, which the defense agrees the instruction was accurate, when the defense is not saying that he applied the wrong legal analysis, like the cases cited by the defense. The issue is hearing the evidence, applying the facts. Was this a fair jury instruction to give to the jury? And we think he got it right, regardless of what the standard is. We think he got it right. But clearly, if it's an abuse of discretion standard, I don't believe an objectively reasonable view of this record could conclude that. And Judge Edwards, you keyed on what I think is the first important point, which is For the defense to suggest that there was direct evidence of negligence belies the very definition of direct versus circumstantial evidence, because direct evidence is evidence which needs no inference. And this was not that kind of case. And if I can remind,
where you have Deputy Shafer being asked, did you push the button when you shouldn't have, in so many words, and he says no. I mean, that's direct evidence. There's other direct evidence you could have had, again, that I alluded to, video of Schaefer and what he was doing, or an electronic audit trail of when he pushed the buttons. But when somebody who's a participant in the event says, I didn't push the button, that's direct evidence for the jury to believe or disbelieve, correct?
yes, sir.
Okay. The other thing, in terms of whether it's discretionary or as a matter of law, it seems both sides agree that you have to prove the three elements, and that the third element, exclusive control, it's clearly there. Whether there's a lot of or very little direct evidence, kind of put that to the side. But how did the plaintiff prove an event like this could not happen but for the negligence of the defendant? That's the thing that's very curious to me, and I'll let y'all know. All three of us on the panel watched the video. We've read everything. So, talk to us at a very detailed, sophisticated level, please.
Well, that may be a challenge, but I'll start with the legal concept. The standard for Judge Helms was not, is there no other possibility that could have happened? And the way the court framed that issue, it sounded to me, and I could have been misinterpreting that you were framing it as if we would have to prove that there was no other possibility. In the McDougall court, the Florida Supreme Court said that there's no requirement to disprove every possibility. Here's what the Florida Supreme Court has said, and I'm quoting from McDougall. The party seeking to apply res ipsa is not required to eliminate with certainty all other possible causes or inferences. In other words, just because a skilled lawyer comes up with a theory and argues the theory to a jury, we're not required to eliminate all of those. The legal question is this, and it's the legal question which was asserted by the Florida Supreme Court in the Goodyear tire case. And here's what it is. Is this an accident which would not, quote, in the ordinary course of events, end quote, have occurred without negligence? Not, is there no other possibility? It is, could this have happened in the ordinary course of events? I'm going to use another phrase from the Florida Supreme Court. They said, is this a, quote, a phenomenon which does not ordinarily happen except in the absence of due care? And Your Honor, in direct answer to where that was addressed in the record, if you look at page 1117 to 1118, Officer Shaffer, and I can run through many other examples, but Officer Shaffer was asked this question: will you agree with me that in order for the gate to close as it did, you would have had to, as a general rule, actually press a button? His answer, yes. To try and make it close, it would definitely be yes. The general rule is that a jail gate does not ordinarily open. When it's placed there to keep inmates in and inmates from getting out, does not ordinarily, in the absence of negligence, actually function as it did that night. And that one singular issue is proven by the actual clear testimony of Officer Shaffer, but we all know that from common sense. No person in
Are you saying that, Mr. Paul, that it was up to the defense if they wanted to rely on the unexpected malfunction theory to prove that occurred?
It certainly wasn't the plaintiff's burden to disprove a speculative theory by the defense. It's certainly not an additional requirement by any of the Florida Supreme Court cases. In fact, it's the opposite, where they say the plaintiff doesn't have to disprove any possibilities. And in this particular case, It was complete and total speculation by the defense that this was a malfunction. There was absolutely no direct evidence to indicate that. And so if the defense's reasoning applied in a forward fashion, it would mean in every situation, the plaintiff doesn't just need to meet their burden of proof, they need to disprove every speculative theory that the defense could possibly come up with. And in this particular case, I would suggest respectfully, the better question to ask is, how unfair from a fundamental perspective would it be for in this situation where a jail gate closes improperly, that everybody agrees improperly, everyone agrees it's under the exclusive control of the defendant, and then the operator says on the night of the incident, it might have happened by rain. Maybe it malfunctioned because of rain. And then the defendant, who's in exclusive control of that gate, who now has been put on notice of it, doesn't investigate it, doesn't go out and look, did this malfunction, doesn't go out and do a repair of this gate, doesn't take it out of service. And then that defendant could later suggest, as defense counsel just suggested, that somehow it would be the plaintiff's burden to disprove this speculative theory. And respectfully, it's not the plaintiff's burden to do that. And that's not the Florida Supreme Court standard. So I'd like to circle back to something else that the court referenced, which is—
Mr. Paul, if I may ask you just a question here, and after breaking down the video, I'd like to know the testimony. The testimony of Officer Shaffer was that ultimately he admitted that he probably pushed the button that opened the gate initially, correct?
Yes, sir.
Okay, so in the video, it shows that the gate is partially open and comes to a stop. There's a button that also, I believe, the control panel, there is a button to stop the opening of the gate. Is that correct?
Yes, sir.
Was there any testimony that that button was pushed by Officer Shaffer?
No, sir.
Okay, and so then when Miss Whitehead walks through the gate starts to close. Was
Yes,
there
sir.
any testimony by Officer Shaffer, either initially or eventually, that he pressed the button to close the gate?
No, sir.
Okay, and then after Mrs. Whitehead walks through the gate then opens in full. Is that correct?
Yes, sir.
So is there any testimony that the button was then pushed to open the gate in full?
Yes, sir.
And that was from Officer Shaffer, correct?
Yes, sir.
And then the gate closes in full after it opens. And was there testimony from Officer Shaffer that he depressed the button to cause it to close in full?
I can't remember that last point, but the bigger idea, if I can, what I believe you're asking is, when the gate stopped, Mrs. Whitehead is waiting to walk through the gate. When the gate stopped, there's no evidence to indicate there was any reason for it stopping other than pressing the button. When the gate restarted after Mrs. Whitehead began walking through, there's no evidence other than negligence to explain why it would have restarted. And that's why the issue of is there anything to indicate that the speculation of the defense that this was the rain, there's no evidence to indicate that the rain would have caused a jail gate that is opening to stop, pause, then restart. There was no one that said that's how a malfunction gate would start. Not that it would start, not that it would stop, but that it would both stop and start. And so the key is the particular facts of this case. And the particular facts of this case, there was no evidence that what happened in that video would happen any other way other than negligence. Did I answer your question?
Yes.
Okay. I did want to circle back on the question of there were two theories that Judge Edwards raised. There was both an operator negligence theory, which is that he pressed the button and that closed on Mrs. Whitehead, and that was negligence. And there was no direct evidence, because in fact, no direct evidence that we could use other than the negligence. There was a second theory, which was negligent maintenance, which was raised by virtue of what the defense was saying. And in this particular case, the jury could have concluded this was evidence of operator error, and that was the reason. They could have concluded it was a negligent maintenance based upon the defendant's contention that this was rain, and the plaintiff suggested, how in the world could we not address through maintenance a rain issue with a jail gate, which is meant to keep people in and not open up for no reason, or both. And so I think it's important that when we look at every single case that the defense cites, there are no cases where there, at least that I saw, where there are two issues, one of operator error and two of a negligent maintenance, which I would respectfully suggest.
I have a question with regard to the answer brief, and I'm looking at the bottom of page 21, going over to the top of page 22. And it says, because Mrs. Whitehead could not directly prove Officer Shaffer pressed a button to close the gate, and there was no proof that the gate malfunctioned due to a lack of maintenance, she was required to rely on circumstantial evidence and so forth. What evidence was there of improper maintenance? You say in your brief there wasn't any, and that's what I've looked through and read through the testimony. I didn't really see any evidence suggesting lack of maintenance.
The argument that the plaintiff made, and it was articulated in final argument, was that the defense suggested that their assertion was, meaning it was their position. So it was in essence an admission that there was a malfunction. And so then it was through circumstantial evidence that a jury could conclude they failed to maintain it. And the way I described it in final argument at the record 1478 was, there's no maintenance records, even though there's not one word of somebody looking at it and fixing it and saying our sensors failed or our sensors misfunction. Is it reasonable in Florida that the weather that we have to have anything outside in a situation at a prison with gates where rain is going to affect it opening or closing or anything like that? And the circumstantial argument was, the defendant's position was that there had been gate malfunctions before, and then we proved there was no maintenance suggestive to this, and therefore the failure, if there had been gate malfunctions before, and if it's true that according to the defense that's caused by rain, a municipality that has a jail gate that does not do anything to address rain causing a gate to open without operator input is negligence. So it was a circumstantial argument. It was not a direct evidence argument. And it was related to, in part, the deposition of Dean Cousins, who was a corporate representative of the county who came to testify on behalf of the maintenance issues. The argument that the defense has made that there was so much evidence to support the plaintiff's theory is directly contradicted by the arguments the defense made at trial. And if you look at the record, pages 1431, 1432, and 1435, this is what was argued to Judge Helms, which is, defense counsel said to Judge Helms, there is no evidence that the gate closed because of the defendant. Defense counsel argued to Judge Helms, there is no evidence that the county breached its duty. Defense counsel argued to Judge Helms at page 1435, there is no evidence of breach. And so respectfully, it seems inconsistent that a lawyer on directed verdict can argue to a court that there's absolutely no evidence and then come in on appeal and suggest that there was overwhelming evidence and there was substantial evidence. We would suggest that is inconsistent with the representations before Judge Helms. Likewise, it seems inconsistent to suggest that Judge Helms didn't have the right to rely on defense counsel's argument in the charge conference where defense counsel said this was an anomaly. This was an anomaly. And so it is reasonable for Judge Helms, having heard all of the evidence, to evaluate what is before him and to conclude that when defense counsel says this is an anomaly, there's no evidence or records to indicate of a short, as defense counsel suggested to the jury. There's no evidence to indicate a water problem, as defense suggested to the jury. And a guard who is there who suggests the general rule, in other words, ordinarily, the only way that the gate would close on her would be if an operator pushed it. It seems more than reasonable for Judge Helms to actually believe this is the kind of case where res ipsa was warranted. Final thought is this. It was barely mentioned. I mean, defense counsel didn't touch the issue of res ipsa one time in his closing argument. I said in what was not a short closing argument, I said less than one sentence about res ipsa loquitur. So the jurors didn't ask any questions about res ipsa loquitur. It was so to make it somehow that that's what this case ultimately was about is different than the actual reality of the case that was tried before Judge Helms. And I would end with this idea. At the end of the day, Judge Helms heard the evidence. He applied the Florida Supreme Court decision. He really did get it right. No one should look at a jail gate that closes on someone in the public and then suggest somehow that is not the kind of thing that happens ordinarily when someone was negligent. Thank you.
Mr. O'Connor, you've got a little over 3 minutes.
Thank you. Appreciate the report again. This is not strict liability. A gate, a piece of equipment failing is not, in a vacuum, is not negligence. The phrase, there is overwhelming evidence of negligence, is not mine. It was uttered by Mr. Paul in his closing argument. And then he transitioned to a reminder and his exhortation to read the res ipsa instruction. And the reason is he wanted he wanted sort of a legal mulligan, because that instruction changes the burden of proof and it requires the defendant to put on evidence that it wasn't negligent. That's a big deal. That's a game changer. Some additional evidence of direct evidence of negligence that was established at trial. I don't know whether you can see, this is my cell phone. Mr. Paul elicited from Officer Shaffer that the size of his monitor, the size of the screen on his monitor was the size of his cell phone. He elicited the dimensions of the room, how far he stood or sat from this monitor that had split screens, much like what we're doing right now. That's all direct evidence of negligence. And then he argued that he wasn't paying attention, didn't see or assume she had passed through. It's all direct evidence of negligence. And Judge Edwards, that question never would have been raised had the court not been instructed on res ipsa. That's the only logical. Can you talk about an inference? That is a powerful inference. And we objected to that instruction every possible way. But we can't infer or assume what the jurors are saying. We can't. We just can't. And on the standard of review, this is not a case where a judge decides to give a chapter 316 special instruction. This is a case where the court misinterprets the law, erroneously so, and changes the landscape, changes the burden of proof.
Let me ask you to focus real quick on the concept of whether this is an event that would ordinarily not occur but for somebody's negligence. Again, Schaefer seemed to testify it should only close if he pushed the button, and maybe there was some other kind of malfunction. How do you answer Mr. Paul's recitation of Florida Supreme Court language saying it's not up to the plaintiff to disprove everything? That's something I'd like you to address, and maybe if Judge Wallace would give you an extra 30 seconds if you need it.
So there's equipment, there are tires, there are things that we all understand. Then there's sophisticated equipment that has components, and equipment can fail, just like an escalator can stop because a breaker is tripped. Just like an elevator can stop and not be leveled because of a mechanical component. Our experience at the jail was that this gate was working just fine. We maintained it. We had a schedule of maintenance. We had dedicated individuals who maintained these gates and these doors. That's reasonable. We have an obligation to exercise reasonable care. Things can happen in the absence of negligence, and things do, and they can happen. But it doesn't mean that the owner of the property failed to exercise reasonable care. We're not looking for the nuclear option here, judges. We just want a trial where the jury is instructed properly on the law. What Judge Helms did here, and as I asked him, in your experience, have you ever had this issue? I asked him rhetorically. Sometimes I wonder what I say when I read these transcripts. And we had an exchange, and I would ask you, gentlemen, the same question in your years as a trial lawyer and as a judge. I wonder about your dads and your father-in-law, what they would have done on this as I drove in today. But what Judge Helms did was this, and it's referenced by Judge Smith in the Goodyear case. Judge Helms, with a finishing stroke administered by the charging judge, Helms, in a plaintiff's case which is built by step until the last on ordinary circumstantial evidence that the defendant was negligent and the plaintiff was not. That's what happened here. All we want is a chance to try the case on the proper law, not with an erroneous, harmful jury instruction which changed everything. What we're requesting from the court is simply a new trial where the jury is properly instructed on the law. Thank you all very much.
Thank you, counsel. I can say for my part, thoroughly enjoy a case that's well briefed, well argued by two very experienced lawyers. So we thank you for your arguments here this morning, and we will now stand adjourned.
Thanks.
Have a good day.
Thank you.